situation is so bad that the Speaker of the Assembly cannot even appoint a secretary in his own office.
Factual assertions may be confined to.
I'm responding to a question from the court.
The factual assertion we confine to.
No, but for instance, in your just.
If we look at the divergence of administrative structures in all of them, there are three things which stand out. One is the area of competence given to the local government. Second is there a legislative override? That is, a central legislature overrides the local legislature. Third is there an executive override? Does the central executive override the local executive? There's a range of combinations. So, at the most federated level is something like Berlin, which is very high degree of competence. The width of the competence area is broad. No legislative override, no executive override. And the other end of the spectrum is very narrow competence. Legislative override, executive override. But in none of them, and that's important for our case, none of them, the services in the local government are sought to be controlled by the center. In none of them, across the board, irrespective of the combination of these three factors, that within the area of competence, the federal government seeks to say, I will control your officers. It just doesn't happen. Then, there is an example of London. Like your Lordship is aware, London, is the most centralized democracy, not just possibly in the Western world, but in the world. Similar to Article 39AA, in 1999, they enacted a Greater London Authority Act 1999. They established a Greater London Authority. That, established a directly elected assembly, 25 members of the assembly, and a mayor. There have been 3 mayors in London till now: Ken Livingstone, Boris Johnson, who then became the Prime Minister, and presently is a gentleman called Sadiq Khan. Interestingly, it's a little similar. When Boris Johnson was the mayor, the Labour government was in power in the centre. And today Sadiq Khan is from Labour and the Tories are in power. So, but there, Section 67 and 70, you Lordships will just make a note, it's there in my written submission. The power to appoint the staff to set their conditions of service, everything is with the authority. Why should us have a central government have any interest in that? And this is not even a federated system. The first line was the examples I gave of federated systems. UK is not even a federation. Their House of Lords is not like our Rajya Sabha, which represents state interests. The House of Lords is a bunch of peers which are appointed through a certain process, but there's no federal interest. Even in a country where there's no federal interest, the management of the capital at a local level, there's no interest of the central government in controlling the services of that. And finally, I will come to our own Delhi Municipal Corporation Act, and that I'd like to just place the sections. The MCD Act, which has been enacted by the Parliament, para 16 of my supplementary written submissions, which your Lordships will have. Section 89 and 90 of the MCD Act give the power to appoint. Section 89 is for important posts. Your Lordships will just make a note of it. For important certain designated posts, the power is with the corporation itself. That is with the elected arm. Corporation is the elected arm. And under Section 89, the power is with the corporation itself.
Yes.
To appoint certain important people to certain important posts. Under Section 90, the standing committee, which is the elected sub-body of the corporation, approves different posts. Under Section 90, they approve different posts for the corporation, and in pursuance of that approval, then the commissioner makes the actual appointment. So there is complete elected arm control under the MCD Act. Well, surely a parliamentary form of democracy with a Westminster style system with federalism in play, we can't be worse off than the Municipal Corporation of Delhi.
So the power to appoint is again there, not given to the center, but.
That's right. And insofar as any concern, I possibly cannot see any concern of the union in the day-to-day administration of the government of Delhi. And your Lordships will test this, because all matters of federalism which has come before this court are in the context of 2 different political parties. That's been the jurisprudence in the 70s. Before that, because one party ruled, we didn't even have cases before this court. Because your Lordships will give a construction which will bear the weight of competing priorities by 2 different political parties.
Right. Anything else, Mr. Farad, sir?
So, finally, if there is a concern, if at all, once services come in the remit, If there is at all a concern, plus that can be taken care of by Article 239 AA4 proviso, the power of reference. Your Lordships have already held that in cases of extreme importance, the matter can be referred to the President and the President's decision is binding. The same will apply in case of services. So we are not in a position to damage any interest of the union. Like Dr. Singhvi said, we are just protecting our house. It's already circumscribed for us, but can we even function within our house? So I'll just conclude my submission with that your Lordships will grant us entry 41, both as a for the purpose of legislation and executive, and the power to transfer and post officials who may belong to central service who, as per their own rules, we are entitled to. And there is no concern of the central government in interfering in day-to-day affairs of our. But I'm extremely grateful for that.
No, 1 minute. What do you mean by legislative power with respect to entry? Because it's a cadre post, correct? The services are allocated to the Delhi government, correct?
Yes.
Where is the question of legislature? What to be legislated?
So, that impune notification does
because so far as the education qualification, everything, mode of appointment, you can't have. Then what type of legislative power you want?
So, may I attempt to answer?
Yeah.
The impune notification does two things. It says I don't have entry 41 available to wear my legislature. It does that first. So, we need that even for creating a post. Your Lordship is right. Certain posts, the top post will always be cadre post. In a principal secretary in a department will be a cadre post, will be all India service person. And that's why we showed to your Lordship those rules. That even vis-a-vis him, we have the power to post within. But for everything else, for creating posts, if I'm creating a hospital, a health service, I need to create posts for that. Can my legislature pass that act? It can. And I need entry 41 for that. What does the impune notification say? I can't, because I don't have entry 41.
But tell us something in the Delhi government hospitals, for instance.
Yes, ma'am.
You already have Delhi government hospitals. You have Delhi government schools. What about the ministerial posts? Like who has legislated, who sanctions the post, who appoints?
So post 2015, we have been earlier. There was what the way it used to happen was the ministers concerned would do it, and the matter will go up to the LG in the normal mechanism as a matter of communication. Now what happens? We have no play. The situation is so bad that the Speaker of the Assembly cannot even appoint a secretary in his own office.
Factual assertions may be confined to.
I'm responding to a question from the court.
The factual assertion we confine to.
No, but for instance, in your just as a matter of clarification,
yes,
in any Delhi government hospital, you would have n number of posts. Who has sanctioned those posts in the past? They were sanctioned by the Delhi government.
So, there is a certain level of what has happened is there is a certain level of ossification in time which has happened post 2015. I am not in a position to create more posts. Whatever had been already done. Now it's the LG doing it his. If at all we request him, if it's created, if it is not created, all of that is happening. But whatever was there pre-2015 is continuing.
Let me very quick to ask a direct question. After all, 239 AA has been there from 1992. There have been at least 3 governments or 4 governments of NCT between that time and now. So it's not the law has changed. Let's be very frank. The law has not changed. The harmony of working has changed, which is why do you have litigation? Why do you not?
All right.
Today, what your Lordship is asking is, the correct answer is this, that the posts were created long ago. Please look at the last 2-3 years. Any post is created, transferred, appointed, can't be. Because how long can we keep on arguing on letters that the actual bus will be gone, the person will be dead, the patient will not be required, COVID will be gone. We can't argue on these things. So it needs clarity only from a Supreme Court. Otherwise, we can keep on having
to say, my learned may not say that.
No, but I have to say something. I can't speak here, We are not living in the Antariksh. We are living in Delhi.
Thank you.
We're talking about context.
Thank you, Mr. Farasad.
Grateful to you.